seated, please. Mr. Capiro.
Thank you, Your Honor. We're before the court this morning in the matter of the State of Ohio versus Brian A. Anthony, case numbers 18 CR 671. The defendant is present in the courtroom with his attorneys, Mr. Rick Perez, Mr. Hector Martinez. Now, Your Honor, you're before the court this morning for a change of plea hearing. Before we get there, at this time, the state moves to dismiss count 4. That count is the felony of the second degree stopping after accident count. The state moves to dismiss that count because it cannot be substantiated by the evidence. To be guilty of the F2 stopping after an accident, the law requires that the defendant himself subjectively, at the time that he committed the offense, knew that he struck a person and that he killed that person prior to leaving the scene of the crash. The state of Ohio has exhaustively investigated that legal requirement, including but not limited to the crash reconstruction, creating a three-dimensional crash reconstruction with the aid of a forensic crash reconstruction firm, reenacting the crash under the same conditions, a computer-enhanced frame-by-frame analysis of the dash cam video in this matter that shows the defendant driving his Jeep past the two police cruisers and the Toyota Camry that are parked on the side of the road that Officer Mazzani is standing next to when he gets struck. Dash cam video of the events that occurred on scene after and simultaneous with that event. Review of the interviews of witnesses on scene at the time of the collision. Also, subsequent testimony of witnesses to the collision and witnesses of the defendant's actions prior to the crash, in the earlier evening, and in the hours after the crash, and then at the time of his arrest. In doing that, the state has determined that the evidence does not lead to the conclusion, as required by the law, that the defendant himself subjectively knew at the time that he committed this offense that he struck a person, and more importantly, that as a result of that, he killed a person. So, based on that, the state cannot prosecute this defendant on that F2 count. Accordingly, the state moves to dismiss count 4, the F2 stopping after an accident, and then also to renumber the charges in this indictment, Your Honor, so that count 5, that's the F3 stopping after an accident, would now be listed as count number 4 on the indictment. Now, Your Honor, the state notified the defense counsel this determination and also notified defense counsel that the state is prepared to proceed on all other counts of the indictment to go to trial. The state is ready to proceed to trial on all other counts of the indictment. And let me say, there is no agreement in this case, Your Honor. There is no plea bargain. It is my understanding that the defendant wishes to waive his right to a trial and wishes to plead guilty to all of the counts on the indictment at this time. That's why we're here.
All right, Mr. Perez, as to the dismissal of the original count 4.
Well, Your Honor, it has been our position since the commencement of this case back in August that the evidence did not substantiate that Brian knew that he hit a person. That's been our position throughout. We pointed out the evidence that indicates that. We're pleased that the state has finally come to the determination that Brian did not know that he hit a person, and the evidence doesn't substantiate that. And that's the evidence that the state has had since August. So we're glad that they're finally taking that position, which has been our position from the beginning. Brian is prepared to enter a plea today to the remaining counts.
All right, then, the original count 4 will be dismissed. Count 5 then will be renumbered as count 4. All right, you are Brian A. Anthony.
Yes, Your Honor.
How old are you?
I'm 25,
How far did you go through school?
about a year of college, Your Honor.
Are you a United States citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court today, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Anxiety?
Do you have that diagnosis?
No. No.
Are you under any treatment for that?
No, sir.
Okay. Did you get a copy of the indictment in this case?
Yes, I did.
All right, now, the indictment as amended contains 4 counts. The first count says that on or about June 24, 2018 in Mentor in Lake County, that you did, while operating or participating in the operation of a motor vehicle, as defined in section 4501.01 of the revised code, cause the death of Patrolman Matthew J. Mazzani as the proximate result of committing a violation of revised code 4511.19A, that being operating a vehicle under the influence of alcohol, a drug of abuse, or a combination. This act is aggravated vehicular homicide, and it's a felony of the 2nd degree. And upon conviction of this offense, the court shall impose as a mandatory prison term one of the prison terms prescribed for the felony of the 2nd degree. You understand the nature of the charge in count 1?
Yes, Your Honor.
Do you have any questions about that charge or the elements of that charge?
No, sir.
Count 2 says that on or about June 24, 2018 in Mentor in Lake County, that you did operate a vehicle while under the influence of alcohol, a drug of abuse, or a combination of them. This is the act of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a misdemeanor of the 1st degree. Do you understand the nature of the charge in count 2?
Yes, Your Honor.
Any questions about that charge or the elements of that charge? Count 3 says that on or about June 24, 2018 in the city of Mentor in Lake County, that you did, while operating a motor vehicle, approach a stationary public safety vehicle or emergency vehicle that was displaying the appropriate visual signals by means of flashing, oscillating, or rotating lights as prescribed in section 4513.17 of the revised code, and that you were traveling on a highway that consists of at least 2 lanes that carry traffic in the same direction of travel as that of his motor vehicle, and did not proceed with due caution or with due regard to the road, weather, and traffic conditions, that you failed to change lanes into a lane that was not adjacent to the stationary public safety vehicle or emergency vehicle. This act is duties upon approaching stationary public safety vehicle displaying emergency light. It is a minor misdemeanor. Do you understand the nature of the charge in count 3?
Yes, Your Honor.
Any questions about that charge or the elements of that charge?
No, sir.
All right, count 4, as renumbered, states that on or about June 24, 2018 in Mentor in Lake County, that you did, while operating a motor vehicle upon a public road or highway, that you were involved in an accident or collision with persons or property, and having knowledge of such accident or collision, did fail to immediately stop your motor vehicle at the scene of the accident or collision, and did fail to remain at the scene of the accident or collision, and did fail to give your name, address, and registration number of your motor vehicle to all of the following: any person injured in the accident or collision, the operator or occupant of any motor vehicle damaged in the accident or collision, and the police officer at the scene of the accident or collision, and that you did fail to notify the nearest police authority concerning the location of the accident or collision, as the injured person in the accident or collision was unable to comprehend and record the information required to be given by you. The accident or collision that is the basis of this violation resulted in the death of a person. This act, stopping after accident, is a felony of the 3rd degree. Do you understand the nature of the charge in count 4?
Yes, Your Honor.
Any questions about that charge or the elements of that charge?
No.
All right, now, before accepting your guilty plea, I need to determine that you know and understand the rights that you'll be giving up, the consequences of your guilty plea, and the maximum penalty that could be imposed upon you. and I need to be satisfied that your guilty plea is being entered freely, knowingly, and voluntarily. So I'm going to ask you a number of questions. If at any time you don't understand a question or you want some additional time to talk to your attorneys, then stop me and I'll give you whatever time you need. Do you understand that?
Yes, sir.
You understand you have a right to a trial, either to me as a judge or to a jury of 12 Lake County citizens.
Yes.
Do you understand that if you have a jury trial, all 12 members on that jury must unanimously agree to a verdict of guilty before you can be found guilty?
Yes, Your Honor.
You understand by pleading guilty today, you're waiving your right to a jury trial.
Yes, sir.
Now, in order to prove that you're guilty of these charges beyond a reasonable doubt at a trial, the prosecutor will call witnesses to testify against you. After those witnesses are done testifying for the prosecutor, then your attorneys would have the chance to cross-examine those witnesses to get out any information they believe helps your case. Do you understand that?
Yes, sir.
You have the right at a trial to bring witnesses to court to testify for you if you want. If those witnesses refuse to come to court, I could issue an order that's called a subpoena, which would force them to come here and testify. Do you understand that?
Yes, Your Honor.
You have the right to testify at trial if you want to. You also have the right not to testify if you don't want to. That decision is completely up to you. That means nobody could force you to testify at trial. Do you understand that?
Yes, Your Honor.
If you decide not to testify at trial, your silence cannot be used against you, and nobody could say anything about your silence at trial. Do you understand that?
Yes, Your Honor.
You understand that if you went to trial and were found guilty, you would have the right to appeal that guilty finding.
Yes, Your Honor.
And if you were found guilty and wanted to appeal, you'd have the right to be represented by a lawyer during that appeal. If you couldn't afford a lawyer, one would be appointed to represent you free of cost to you. Do you understand that?
Yes, Your Honor.
You also understand if you could not afford a transcript of the trial, it would be given to you at no cost.
Yes, Your Honor.
If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of the rights we've talked about so far?
No, sir.
Do you still want to plead guilty to these 4 charges?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to those charges?
Yes, Your Honor.
And you understand that by pleading guilty to these 2 felonies and 2 misdemeanors, that you're voluntarily giving up your freedom for whatever period of time under the law that I could sentence you to prison?
Yes, Your Honor.
All right, now in count 1, the charge of aggravated vehicular homicide is a felony of the 2nd degree. That carries with it a maximum prison term of 8 years and a maximum fine of $15,000. Do you understand that?
Yes, Your Honor.
In count 2, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them is a misdemeanor of the 1st degree, and that carries with it a maximum prison term of 180 days. Do you understand that?
Yes, Your Honor.
And it's a maximum fine of $1,075 with a minimum of $375, and that fine, whatever fine I give you is a mandatory fine. Do you understand that?
Yes, Your Honor.
In count 3, duties upon approaching a stationary public safety vehicle displaying emergency light is a minor misdemeanor. It carries with it a maximum fine of $150. Do you understand that?
Yes, sir.
And in count 4, stopping after an accident is a felony of the 3rd degree. It carries with it a maximum prison term of 36 months and a maximum fine of $5,000. Do you understand that?
Yes, Your Honor.
Any questions about any of those penalties?
No, Your Honor.
Now, the law allows me to impose consecutive sentences depending on certain findings for these separate offenses. If I impose consecutive sentences in this case, do you understand that you're facing a maximum prison term of 11 years plus 180 days and a maximum fine of $21,225?
Yes, Your Honor.
Now, with regard to count 1, aggravated vehicular homicide, there is a mandatory prison term that must be imposed upon you by law, so you cannot be sentenced to community control. Do you understand that?
Yes, Your Honor.
The mandatory prison term means that there can be no judicial release during the term of your incarceration. Do you understand that?
Yes, Your Honor.
Are you on probation right now to any court?
No.
Are you on post-release control to the Adult Parole Authority?
No, Your Honor.
All right, do you understand that your guilty plea on count 2 will result in a lifetime mandatory license suspension?
Yes, Your Honor.
You understand that your plea of guilty to count 2, the OVI, would result in a mandatory license suspension of between 1 and 3 years.
Yes, Your Honor.
And you understand that your plea of guilty to count 3 will result in a mandatory license suspension of between 6 months and 3 years.
Yes, Your Honor.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that if upon your release from prison, you will have to serve a period of post-release control as part of your sentence after your release for a period of 3 years under the direction of the Adult Parole Authority?
Yes, Your Honor.
Do you understand that when you are on post-release control, conditions will be placed upon you? If you violate any of the conditions of your post-release control, the Adult Parole Authority could return you to prison for up to 9 months for each violation, up to 1/2 the time I give you in this case, and that's all as part of this sentence.
Yes, Your Honor.
Do you understand that if your violation of post-release control is a new felony, then whatever court you're in, that judge could give you an additional consecutive prison sentence for that post-release control violation?
Yes, Your Honor.
And you understand if that occurs, that sentence would be the greater of 12 months or the time you have left under the 3 years of post-release control.
Yes, Your Honor.
All right, as I told you a little bit earlier, whatever sentence you receive on count 1, the aggravated vehicular homicide, is mandatory. You do understand that, right?
Yes, sir.
And you understand that during the course of that mandatory term, you are not eligible for judicial release.
Yes, Your Honor.
If I give you additional time beyond that mandatory time, specifically on counts 4 and count 3, that this is after your mandatory time is done, you would be eligible for judicial release at a certain time, but it's not something that is automatically granted. You understand that?
Yes, sir.
Any questions about that at all?
No, Your Honor.
Has anybody promised you I would be lenient on you because you're pleading guilty?
No, Your Honor.
Has anybody promised you what your sentence will be in this case?
No.
Do you understand that at the time of sentencing, I do not have to follow the recommendations of either the prosecutor or of your attorneys?
Yes, Your Honor.
Have you had enough time to consult with your attorneys before pleading guilty today?
Yes, Your Honor.
Have they discussed everything about your case and answered all your questions?
Yes, Your Honor.
Are you satisfied with the advice they've given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you entering this guilty plea freely and voluntarily?
Yes.
Do you have any questions at all before we go any further?
No, Your Honor.
All right, Mr. DePiero, if the case were to proceed to trial, what would the evidence show?
Well, Your Honor, if I may.
Yeah.
Please, and perhaps I missed it. Your Honor did notify the defendant, and he knows it's right here on the form, that the felony of the second-degree aggravated vehicular homicide count carries with it a mandatory term of imprisonment of up to 8 years. And I didn't hear whether or not Your Honor notified him that it is a minimum of at least 2 years.
No, I did not.
Okay.
I mean,
All right.
do you have any question about that?
No, Your Honor.
What I told you was you're not eligible for community control because there is going to be a mandatory prison term of at least 2 years, and I told you the maximum is 8. Do you understand that?
Yes, Your Honor.
Any questions about that?
No.
Okay, Mr. DePiero, go ahead.
Thank you, Your Honor. Your Honor, the facts that I will summarize at this time are facts that are shown through the discovery that the state provided to defense counsel throughout the pendency of this matter. And this summarizes an outline of what the state's evidence would be if this matter were to proceed to trial. The evidence would show that on June 23rd, 2018, the defendant, Brian A. Anthony, made arrangements with a friend to go over to his friend's house in Lakeline, which is in Lake County, Ohio, that evening and drink some alcohol and go to downtown Willoughby. The evidence would show at 7:30 p.m. the defendant purchased a 6-pack of Summer Shandy brand beer and also an 18-pack of Miller Lite brand beer from the Shell gas station on Shard Road in Willoughby. Thereafter, the defendant got in his car, which is a car that he leased. It was a 2017 Jeep Wrangler. And he went over to his friend's house there in Lakeline, Your Honor, and met some friends over there, and he proceeded to drink multiple alcoholic beverages out in the garage at the house with these people. This included multiple beers and liquor shots. At that time, the defendant drank to the point of intoxication. Now, at 10:14 p.m., the defendant, along with the others, they were going to go down to downtown Willoughby, and so they arranged for an Uber rideshare to transport them there. And they got one. This Uber rideshare came out picked them up, and they arrived in downtown Willoughby at 10:29 p.m. on June 23rd, 2018. There, the defendant continued to consume alcohol. The evidence would show that there's a receipt from the 1899 pub there in downtown Willoughby. Shows the defendant used his bank account, credit debit card to purchase Miller Lite beer and 3 green tea liquor shots. That was at 10:51 p.m. At 11:47 p.m., the defendant himself is alone at this point. He was picked up by a different Uber driver in downtown Willoughby. At the defendant's request, the Uber driver transported the defendant back to the friend's house in Lakeland, and that's where the defendant's Jeep was parked. So the Uber driver did that. Now this Uber driver, Your Honor, he's a former Air Force EMT, he's a certified emergency medical technician. He's familiar with the physical characteristics exhibited by an intoxicated person. Routinely transports intoxicated people via his job as an Uber driver, and he observed the defendant to exhibit signs of intoxication when he picked him up, including slurred words, clumsiness, moving as if he was impaired by alcohol. The Uber driver dropped off the defendant at that Lakeline house. It was at 11:57 p.m. Through the course of investigation, the Mentor Police Department determined that the defendant had been in possession of the defendant's cell phone throughout the evening, June 23rd, and into the early morning hours of June 24th, 2018, and that the defendant had used his cell phone to communicate with others, and this is via text message, iMessage, voice calls. Mentor Police detectives obtained the defendant's cell phone records from Verizon Wireless, and these records, they provided some text message content. They provided cell tower location information that the investigating officers used to track the defendant's location after the Uber driver dropped him off back at that Lakeline house at 11:57 p.m. Using the cell tower information, the Mentor Police officers followed the defendant's travel path. And as they did that, they found that there were businesses along the path that had exterior cameras outside of their structures, their buildings. And so the Mentor Police Department gathered that surveillance video along that path. And this is in the hour that is preceding the collision that killed Officer Mazzani. The cell tower records and the surveillance video shows that the defendant traveled in his Jeep Wrangler from Lakeline into Euclid, Ohio, Your Honor, at 12:13 a.m., and now we're into June 24, 2018. Surveillance video from an exterior camera that is in line with the cell tower location information from the defendant's phone shows the defendant's Jeep Wrangler traveling eastbound on Lakeland Boulevard. And you can see in the surveillance video that the defendant's vehicle is on the roadway, and it travels off of the roadway onto the grassy left-hand berm, and for at least 10 feet almost strikes a chain link fence that's there, then corrects and goes back on the roadway. Keeps on driving. And then about a minute later, the defendant is on video at a BP station there in Euclid, and shows the defendant pull up to a gas pump. You see the defendant exit his vehicle. He's the driver and the sole occupant of the Jeep Wrangler at that time. The defendant enters into the BP station, goes into an ATM machine, withdraws $100 out of the ATM machine, walks back out to his Jeep, gets in the driver's seat, and drives away. About 10 minutes later, a license reader at East 222nd Euclid Avenue picks up the defendant's vehicle traveling in the general direction of a road called Harms Road, Your Honor. And at 12:30, GPS places the defendant's phone at 22901 Harms Road, not too far from there. Now, some of those cell phone records that I mentioned earlier did have some cell phone content that were recovered, and also a number of texts were observed in those cell phone records, and the person who the communication was happening with, the defendant was communicating with, was found, and his phone was checked and downloaded. And those text message content is consistent with the defendant at that time purchasing drugs around this time at a location near 22901 Harms Road. Also within that time frame, Your Honor, right at that time, those text messages, there's text message from the defendant stating he could not find his keys, and then a minute later that he found. Then he drove away, and at 12:54, video surveillance shows the defendant driving his Jeep Wrangler on the I-90 in Euclid in the direction of Route 2 eastbound. Now, Your Honor, State Route 2, it's a public roadway, consists of 3 lanes of travel in each direction. It's a 60-mile-per-hour limit. Shortly before 1 o'clock, June 24, 2018, Medical Patrol Officer Matthew Mazzani was assisting Medical Patrol Officer Marianne Chalupka on a traffic stop. Officer Chalupka had made a traffic stop on a Toyota Camry for a traffic violation, and this was on State Route 2 in the city of Mentor, Lake County, Ohio, between Route 306 and the 615 exits there, around milepost 216, between 306 and 615. Both Officer Mazzani and Officer Chalupka were driving police cruisers, so these are cars that are clearly marked as police cars, and at the time that both of the police cruisers were parked on the right side berm, they had their emergency red and blue rotating police light bar lights activated and flashing. They were parked behind this Toyota Camry that stopped on the berm. The roadway was dry. The weather was fair. Visibility was clear and the traffic was light. Now, Officer Mazzani stood outside Patrol Officer Chalupka's driver's side window at the side of the car as the officers, and Officer Chalupka was seated inside for a cruiser. Your Honor, Officer Mazzani is speaking with Officer Chalupka about what action they were going to take on this traffic stop. There were 2 occupants, a driver and a front seat passenger of the Toyota Camry. They were seated in their vehicle at all times. So at 1:03:58 a.m., as Officer Matthew Mazzani stood outside next to the driver's side window, the defendant drove his Jeep Wrangler in the right-hand lane of State Route 2 eastbound. It's the lane adjacent to the right berm, towards the location of where Officer Mazzani was standing, where the cruisers were parked. No other car was traveling around or near the defendant that would prevent him from moving over as the law requires. He did not move over as he approached these 2 cruisers in the Toyota. He was traveling at about 60 miles an hour, which is about 88 feet per second. As he approached the defendant, driving his Jeep Wrangler under the influence and impaired, struck Officer Mazzani's body, full speed, highway speed. As he did that, the defendant's vehicle sideswiped Officer Chalupka's cruiser, the driver's side of her car, and also the driver's side of the Camry. So there was a collision with the cars as well. The dash cam video shows that after the impact and after that collision, the defendant activates his brake lights, but his car continues to move forward at this speed. The person in the driver's seat of the Toyota observed the defendant to drive his Jeep forward and to the right berm and to slow down. But the defendant did not stop his vehicle after the collision. He continued to drive eastbound on Route 2. He did not provide any information to anybody. He didn't stop, or any of the other information as required by law. Now, at the point of impact between the defendant's Jeep and Officer Mazzani. Officer Mazzani's body became pinned between the Jeep and the cruiser as the Jeep continued to travel forward at highway speeds. Officer Mazzani's body did not travel onto the Jeep, but was thrust forward and to the right in a cartwheel fashion and upside down. Officer Mazzani's body struck the rear of the Toyota Camry that had been stopped. The hood or the trunk of the Camry was dented fully inward and upward, obstructing view from the front of the car. And the force of that impact caused that Toyota to be from a stop to jump to 2.9 miles per hour. Great force. Officer Chalupka, sitting in her vehicle, sees this. She exited her cruiser at that time, called for help. As a result of the defendant operating his Jeep impaired by alcohol or drug abuse, or a combination of them is charged, he struck Officer Mazzani. Officer Mazzani died from the injuries inflicted from the defendant hitting. Multiple blunt force trauma with skull fractures and crush injuries to the thorax, to be specific, Your Honor.